Hello everyone. Today I will discuss the topic cognizance of offences. Now, in this video, I will discuss what is the meaning of the term cognizance, when and how cognizance is taken by the magistrate, and what happens when the magistrate who does not have the power to take cognizance takes cognizance. Okay, cognizance word is not defined in CRPC. Okay, it comes from the old French word connaissance, which means to take note of. Now, who takes note of what? The magistrate takes note of an offense. Okay, see, remember, cognizance is not taking note of the accused. Cognizance accused के ऊपर नहीं लिया जाता है. Cognizance is always taken of an offense, suspected commission of an offense. Okay, so we can say in simple terms that cognizance means taking judicial notice of a commission of an offense. Now, there is an old case which has discussed what is meant by taking cognizance. That case is R. Chari versus State of UP, AIR 1951. In that case, the court says, taking of cognizance occurs as soon as a magistrate applies his mind to the suspected commission of offense. Okay, so as soon as, that means that as soon as the magistrate decides to proceed further, he is said to have taken cognizance of the offense. Okay, now who has the power to take cognizance? Every judge, every magistrate has the power to take cognizance. CRPC talks about only the magistrate of the first class, magistrate of the second class, and sessions court. Supreme Court and High Court also have the power to take cognizance. Supreme Court, you must have seen in the news and all that, takes suo motu contempt. वो क्या है? That is the power to take cognizance. It takes cognizance on the offense of contempt against it. Constitution authorizes it to do so. Okay, coming back to CRPC. Chapter 14 of CRPC from section 190 to 199 deals with the cognizance, the power of magistrate and the sessions court to take cognizance. Now, 190 deals with the power of magistrate to take cognizance, and 193 talks about power of sessions court to take cognizance. Okay, we'll first discuss power of magistrate to take cognizance, that is under 190. Section 190 subclause 1 says that the magistrate of first class or the magistrate of the second class, if he is empowered to do so, may take cognizance upon these the three enumerated scenarios. What are those three enumerated scenarios? The first is upon the complaint. When a complaint is filed under section 200, the magistrate can take cognizance. Second is police report. When the police report is filed under section 173, the magistrate can take cognizance. Third one is, which is very rare, that is the magistrate also has the power to take cognizance upon his own knowledge or information given by some person other than a police officer. Why other than a police officer? Police officer का information is generally the police report, the charge sheet that is filed, and वो होगा तो obviously that will fall under clause B. So इसका एक example, we have a very good example. Say first करो, a magistrate is going somewhere, he's gone, of course in his own jurisdiction. Okay, and he sees an offense being committed in front of his eyes. He can take cognizance. That will fall under the category, third category, that is 191C. Okay, so 190 तो हो गया, power of magistrate to take cognizance. Now सेशंस कोर्ट का पावर कहाँ है? ठीक है, सेशंस कोर्ट पावर is discussed in 193. What does it say? It says that it actually puts a bar on the sessions court to take cognizance unless and until the matter is committed to it by the magistrate. Now committed क्या होता है? What do you mean by committal? Section 209 of CRPC talks about committal. See, when a charge sheet is filed or a complaint is filed before a magistrate of an offence, and magistrate says that that offence is not triable by him, that offence is exclusively triable by the sessions court. So what does he do? He commits the matter to the session court. Okay, that is dealt with by section 209. So coming back to 193, what does 193 says? Ki unless and until the matter is, this case is committed to the sessions court will not take cognizance. Okay, ye. Acha, we have to read this with 199 also. 193 also says that unless and until provided by the CRPC. So CRPC, when does CRPC provides or where does CRPC provides that sessions court can take cognizance? Sessions court can take cognizance of matters relating to defamation pertaining to the president, vice president, prime minister, administrator of the union territory, governor, so on and so forth. In loca pertaining, if there is a matter of defamation, if there is an offence of defamation, then the sessions court can take cognizance as the court of original jurisdiction. तब committal की ज़रूरत नहीं है. Okay, understood? The sessions court can take cognizance in cases of defamation according to section 199, or when the matter is, when the case is committed to it by a magistrate under section 209. Now, going outside the purview of CRPC, sessions court in certain offences can also take cognizance. For example, NDPS Act में, SC/ST Act में, PMLA में, sessions court has certain special criminal laws give power to sessions court to take cognizance. Okay, but since CRPC generally we read with IPC only, so we may say that sessions court has power to take cognizance only in cases of defamation, that is chapter 21 of IPC, and certain other cases dealt with in other special provisions. Okay, IPC में the sessions court can take cognizance when the magistrate has committed the case to it under section 209. I hope I have made myself clear. Okay, now we have seen that 190 talks about the magistrate's power to take cognizance. 193 talks about the power of sessions court. Now how this is taken? How the cognizance is taken? See, as soon as, you will see various judgments which say that as soon as the magistrate decides to proceed further under chapter 15, that means he issues process summons, issues warrant summons and all that, he is said to have taken cognizance. Okay, but practically hota kya hai? What happens? The magistrate, when he takes cognizance, he passes an order of taking cognizance. This passing of order is nowhere required under CRPC, but in practice it happens. एक छोटा सा एक पेज का order होता है in which the magistrate says that he is taking cognizance of such and such offence upon charge sheet filed by the police or upon complaint, whatever it is. Okay. Now, what happens when the magistrate takes cognizance when he does not have the power to do so? उसमें क्या होगा? Now we have seen that there are three clauses and subclauses in section 190 subclause 1. Okay, the three situations enumerated wherein the magistrate can take cognizance. Okay, now when the magistrate does not have power to take cognizance and he does so upon complaint or upon a police report, that is under 190 subclause 1, subclause A or subclause B, and he does so in good faith, erroneously believing that he has the power to take cognizance, and he takes cognizance, then the trial will not be vitiated. That will not affect the merits of the trial. Okay, but when magistrate takes cognizance under clause C, that is upon his own knowledge or information given by some person other than a police officer, then in that case, when he does not have power to take cognizance, that trial will stand vitiated. Are you getting the difference? Under clause A and clause B, that is, upon police report and upon complaint, if magistrate takes cognizance when he does not have the power to take cognizance, trial will not be affected, provided he is taken in good faith erroneously, believing that he has the power. In third scenario, that is in third clause, clause C, when magistrate takes cognizance upon his own knowledge or information by a person other than a police officer, the trial will stand vitiated, irrespective of the fact that he did so in good faith or he erroneously believed that he had the power. उससे कोई फर्क नहीं पड़ता. C में अगर लिया है तो the trial will stand vitiated. Okay. Now in this video what we have seen what is the meaning of the term cognizance, how the cognizance is taken, the power of magistrate and sessions court to take cognizance, and what happens when the magistrate takes cognizance when he does not have power to do so. I hope I have made myself clear. You have understood whatever I have told in this video. Thank you.